Deadly weapons were used, particular sections, the people were targeted, only particular section. This is a porous border and the Bangladesh border.
That is the job of your agency. They will find out. With a view to provide a safeguard to the state or other persons, let the High Court examine that.
But their FIR says deadly weapons were used. Their FIR says 4 to 500, mob of 4 to 500 people.
The manner in which this unfortunate incidents have taken place, I think.
Their NIA slept over it. Then what was the necessity for NIA, without even looking into the records, to initiate this FIR or its powers under 6.5? That request, we are not making any comment on this court.
They might have some objection. This part of the order, that whether UAPA is attracted or not, that should be considered. We will direct the NIA to submit report on sealed cover, and we will request the High Court to re-examine this part. Whether
Can I just 2 minutes? Kindly see section 15 has been invoked. Kindly read me section 15.
That is what we have.
That is a terrorist act. Kindly appreciate this. This is a terrorist act.
What is a terrorist act?
Yes, terrorism. The Delhi judgment.
Yes, clearly fallen.
Kindly just I rely upon a judgment.
No, we will rely first upon the provisions of the act. Then we will go to the judgment.
Provision 15(1)(a).
Please read 15.
15. Whoever does any act with intent to threaten or likely to threaten the unity, integrity, security, or sovereignty of India, or
You are missing economic security.
then India's security terror is likely to strike terror in the people of any section.
Again, Mr. Bandyopadhyay, security, and then there is an amendment.
economic security.
Yes.
And
Section of people
economic
were
security is
targeted.
defined under the Act as something which affects the economic interest by restrictive movement.
15(1)(a) has been invoked. Can you see by using bombs, dynamitic or other
Therefore,
explosive,
Mr. Bandyopadhyay, we also have.
now the other explosive substance. There is no FIR is in the Indian Substantive Act. Can you appreciate this? What I am saying.
This is exactly what we go and tell the High Court
High
that
Court.
this was an incorrect application of mind by the NIA while invoking its suo motu powers under 6.5. A, because there is no use of explosive. There was no intention in the nature of economic security.
I go to
All right. Can you pass this order?
Let us first hear them.
My lord, I am for the writ petitioner. My friend.
I am for the NIA, my lord. I'll tell my lord. Deadly weapons were used, particular sections, the people were targeted, only particular section. This is a porous border and the Bangladesh border, and large number of shops of particular sections were demolished, burnt. Petrol was used, therefore inflammations are, and they are
We are not, Mr. Raju, we are not saying anything today. That is the job of your agency. They will find out. If the agency, on the basis of the material, satisfy the High Court, yes, that the prima facie an offence under this provision made out, the law will take its own course. Nobody can stop. But with a view to provide a safeguard to the state or other persons, let the High Court examine that material and then take a call.
But my lords, we are doing independent investigation. They are supposed to hand over the papers of the investigation to us, which they are not, despite the registration of the FIR. Statutorily, they are mandated to hand it over to us.
There are 2 orders.
That's why we are not.
Therefore, they may be directed to comply with the
That's why
direction of
nobody is
statute.
pushing the order of referring to NIA. That order is we are not there. Also, we now realize that the order has been referred. Order has already been referred to. The NIA will hold an investigation.
Thereafter,
But their FIR says deadly weapons were used. Their FIR says 4 to 500, mob of 4 to 500 people.
Mr. Raju, the state is in challenge to an order which does not direct NIA investigation.
Yes.
It directs consideration.
The central
So we
government
do
will
not
take.
find any reason to interfere with this order. A subsequent event is indicated to us by Mr. Bandyopadhyay that is in tune of this order.
I appreciate.
You have already taken over a decision. So we are not also interdicting that decision. Let that decision be implemented.
enough.
But the issue whether the correctness of the decision to invoke section 15 was right or wrong, because without looking into documents you have said section 15 is applicable. Is it a fair and just exercise of your powers? You have taken a decision without even looking into the documents as you
The
said.
documents which are looked at,
What
So
documents have
therefore,
you looked at?
The High Court
Your case diary was not placed before you. No document is placed. So you have, it's already a
contradiction here. If the record is not produced, then this opinion
It's
can't be followed.
already a pre-decisional conclusion arrived at. Without looking into materials, you say 15 is applicable. So we would request you to look into the materials. We'll direct the state to hand over the papers. And you give your report, as the Honorable Chief Justice indicates, on your independent investigation also, whether prima facie ingredients of 15 are disclosed or not. And the court will, upon hearing both of you, come to a finding on this issue.
In other words,
Well,
this is
I
for the
have one
investigating
another
agency to find out.
But I have one another point. I have preferred this SLP. Kindly keep the point open for the decision. That
Maintainability
we have
issue?
regarding the maintainability.
All right, that.
That because it is a two.
Mr.
The original trial was
Bandyopadhyay, after all, even if it was an independent writ, it would have gone to the Honorable Chief Justice.
I am not.
Not even for a.
I am not
No,
disputing.
don't go into that
I am not
procedural
disputing. We will
nitty-
take it or not.
See,
I am not
the
disputing.
manner in which this unfortunate incidents have taken place, I think the High Court will be.
It's not isolated.
Series of
No,
incidents,
it's
series
not
of FIR.
isolated.
You know, Patwalia, we have seen it happened on April 25, and that is also a very important thing for the High Court to consider. Because in April 25, the High Court Division Bench directed NIA to
Correct.
consider the
Correct.
invocation of their powers under 6(5). And in our understanding, that was much graver incident, where even Mr. Bandyopadhyay agreed to deployment of the Central Armed
Exactly what I was
Forces.
going to say, my lord.
Their NIA slept over it. Then what was the necessity for NIA, without even looking into the records, to initiate this FIR or its powers under 6(5)? That request, we are not making any comment on this court.
Yes,
These
Your
are for the High Court
leave
to
it.
High
examine.
Court seized of the matter, so we don't.
Your lordship, and as my lord had observed, that was my main argument. If your lordship sees that ultimate direction, High Court only says you take a
No,
decision
we
on
see
your
that's-
power, and that suo moto power is there, which has been exercised.
आपको तो fee नहीं मिल रहा है.
Lord, actually, this is a very economically strategic highway, and therefore this is blocked. This is not. Who knows better than my lords, my lord? All.
Every emotional outburst, cannot be packaged as a threat to economics.
We specially petition directed against a self-seeking interlocutory order dated 20th January 2026, even in the absence of any investigation by NIA or any material in support thereof, the order passed by the Government of India specifically recites that the allegations contained in the subject FIR attract section 15 in bracket 1 in bracket small a of UPA Act 1967. Next paragraph. In this regard, we do not deem it appropriate to express any opinion at this stage, at this premature stage. Suffice it will be to direct the National Investigating Agency to submit the report from a post-investigation or during the course of investigation before the division bench of the High Court in a sealed cover as to whether, on the basis of the material stock information gathered by it, any prima facie case for further investigation under provisions of the UPA Act is made out or not. Since there are only passing observations in the impugned order of the High Court, without any definite opinion in relation to attraction of the above stated act, we request the High Court to consider the status report, stroke report to be submitted by NIA independently and issue consequential directions. As we
Also our
require.
submission, my lord, only not the considered to NIA report, but also our considered and also our submissions.
Yes, independently.
Then they may also, sir, give the papers, my lord. They may.
The record will have to be handed
They'll
over.
have, hand over the record.
Yes.
They'll hand over the record.
Arise, my lord, at all. Since your lordship has not.
They don't want to give the record and make submissions.
The
Very unfair.
The parties.
unfair is on your part.
No.
You are unfair so far state of West Bengal is concerned. In your state.
No, I'm sorry. Don't.
Right. We are here deciding a legal issue.
My lord, I understand. My lord, in only in the state of West Bengal, NIA is active. That's also
The
point.
issue as to whether.
What happens there
That's also
is
point.
also well known what happens in, I'm sorry to say.
That you will understand few days, after few
Shall
days.
be decided by.
For me to understand.
All this is not necessary, my lord. Let the record be handed over, my lord. Record will have to be handed over.
Specially petition is accordingly disposed of with the above clarification.
One thing.
Your lordship have said that let the record be handed over. Record will
One
have
thing
to
I
be
just-
handed over.
You have not stayed any portion of the order.
Nobody is before us to ask for this prayer.
May I say
No,
one thing?
Lord, they are not handing over the record. How is the NIA supposed to act?
Now, you see, High Court has at one stage told the government of India, you take a decision.
Correct.
Now, government will take a decision. Let NIA go before the High Court and tell that we need report.
All right, we can do
May I
that. No
just one
difficulty.
thing? We are challenging that substantive order, that order. We have filed a petition.
Just जाके ना dispose of से पहले. Just a minute, Mr. Kalyan. One more paragraph.
We filed a
The-
petition here.
As regard to various other contentions sought to be raised on behalf of the petitioner,
No, how is that?
comma, since the matter is still pending consideration before the High Court, comma,
There is another petition challenging that.
Well, that,
So then
that
if-
may be.
Then he may withdraw the writ.
That will also be disposed of with this order.
I'm saying so. Mr. I'm saying.
sought to be raised in the specially petition, comma, we grant liberty to the petitioner to raise those contentions before the High Court, where the matter is still pending. Also, similarly, if the order passed by Government of India, comma, entrusting the investigation to NIA has also been challenged before the High Court.
No, before this.
32.
Before,
Article 32. Madam, this is the diary number.
don't,
So that will be transferred to the High Court.
Your lordship may dispose it off in the light of this order. We are both agreed.
Or transfer.
at this stage, don't say since, at this stage, it has been brought to our notice by Sri Kalyan Upadhyay, Government Senior Counsel, that State of West Bengal has filed a separate writ petition in bracket criminal number, diary number 7368/2026 before this court, challenging the order dated 28th January 2026 of the Government of India, whereby the investigation has been entrusted to NIA, comma, we are of the view that the legality of that order can also be at this stage examined by the High Court, who is already seized of the matter. And so consequently, we take the writ petition criminal diary number 7368/2026. The number can tell them to assign the number and mention the number on board and dispose of the same by transferring that writ petition to the High Court at Kolkata.
Your lordship may
No, by
dispose
the-
it off.
by
Once
the-
your lordship have said legality of that order is being seen
By
here.
the same.
There is no point in keeping a parallel proceeding pending.
We have transferred, that's why we are
No,
transferred.
but then it can be disposed of here itself. The High Court will pass a
That's
composite.
what we are saying.
Transferred and disposed of.
We have said
But
transferred
my
that.
friend had agreed that in the light of this order, it can be concluded.
Transferred and disposed of.
Transferred now, he has taken cue from
Dispose of,
your lordship.
is already there.
Transferred and disposed.
How does it
Yes.
make any difference?
Well,
It will be a parallel proceeding
No, no,
needlessly.
not-
Not here, transfer to the High
No,
Court.
no, that is right. Once your lordships have said legality of the order is going to be seen, the second proceeding would not make any
That
sense.
is for them to, that this precise objection you will raise in the High Court.
well, let him, if required, he may file a fresh petition, but why this to be
At
transferred?
this stage, my lord, why should,
It is clarified that we have not expressed any opinion on the merits and or maintainability of that writ petition.
But the bench which is season of the matter.
We have disposed of by transferring that writ petition to the High Court.
By the same bench, because in Calcutta High Court.
Oh, that's it. It is further directed that the above stated fresh writ petition filed by State of West Bengal shall also be heard by the division bench headed by Honorable Chief Justice of the High Court, before whom
WPAP 153 of
WPA in bracket P 153 of 2025 and other connected matters are pending.
Yes, yes.
Matters are pending.
Deeply obliged to your lords, grateful to your lords.